This is Josh Nelson from Nelson Elder Care Law. Appreciate you joining us today at 3 o'clock on Wednesday, just like we do every Wednesday, to really go over. Guys, this is Josh Nelson from Nelson Elder Care Law. 3 o'clock on Wednesday, just like we do. Guys, this is Josh Nelson from Nelson Elder Care Law. Appreciate you joining us today at 3 o'clock on Wednesday, just like we do every Wednesday, to really go over some tips and tricks and pointers that we want you to gather and answer any kind of questions you may have. We want it to be a little bit more interactive, something with questions and answers. Otherwise, we'll just go over our topics for today. Today, our big topic is how we make sure that you have peace of mind during troubling times. Whether that be something that's going on with yourself, your parents, your spouse, a friend, or a family member, we want to make sure that you know the information you need to help react to that. We all know that having a plan is better than not having a plan. So often, whenever people start hitting hard times, they don't know what to do. And we want to give them a resource to be able to do that. If you have any questions today about things from the legal side of how we care for somebody, how we protect their assets, what government benefits might be available to somebody, that's what we're here to do. A lot of times, the misnomer of elder care law scares people away. I always laugh. I have 6 clients over 100, and nobody ever considers themselves old. You'll see that I'm missing a little bit of my hair myself, and I always have a client that laughs at me because he's 104 and has more hair than I do. He gets a real kick out of it. But I love his sense of humor. And if you really ask him, one of the tricks to being his age and being healthy really is keeping that positive spirit, having the grit, and keeping that humor alive. We often see that whenever people go through any kind of care event, whether it's as a caregiver or the receiver themselves, having a positive attitude, making sure that you have a plan in place, that you have certainty and peace of mind, really helps get through that with as little stress. And out of all my clients that really make it over 95 and healthy, they say reducing your stress is one of the biggest things that you can do to live that great long life where you aren't necessarily dependent on others. It's really, really important that you think about what would need to happen if something happened to you or your loved ones. That's what we're going to talk about today. In the last couple of weeks, we've gone over things such as Medicaid, VA benefits, general estate planning. We want you to think of those things and not think so much about the elder part of it. What elder care law really is focusing on how we plan to protect your assets, your quality of life, and make sure that you're maximizing any kind of government benefits that may be available to you. That's what we do. Everything's very nuanced, it's very detailed. We have to sit down and get to know you and your situation in order to be able to have a really great plan for you because this isn't the type of work where we just fill in like worksheets or forms with your name to make it so that it's legal. We have people that come in with that type of estate plan, so to speak, and whenever they start really digging into it or trying to use that plan, it's crazy how little protection it really offers. One of the instances that we have is a lady that came in just recently and she had a statutory power of attorney and it wasn't filled out right, even though she paid an attorney to be able to do it. This was really scary because I'd argue that during your lifetime, whether or not you're the caregiver or the care receiver, the financial power of attorney is one of the most important tools that you can have in your toolbox. People always ask, why is your power of attorney so thick? Are you getting paid by word? And I think it's a joke because whenever attorneys used to first create documents, they really did get paid by word. That's why if you look at old deeds, they go on and on and on, where if you look at new deeds, they're just a couple sentences. But all joking aside, what we really need to focus on is the reason that our power of attorney has 26 pages in it is because we have to go through and express everything that you'd want to be able to have your agent do and also how we protect them. So if it's something with your qualified funds like a 401k, a 403b, and your power of attorney goes to try and take that money out on your behalf to pay for medical expenses, which reduces your tax liability on those funds, can they do that? Do they have the power to do that? Maybe you have something where you need to decide, do I pay my assisted living? Do I pay the nursing home? Who do I pay? If some people aren't going to get paid, we want to make sure that if your agent is the one paying them, that they aren't incurring personal liability whenever they do so. Just recently, I had a lady who was going through a care event and she lived in an assisted living. She was very healthy there and had been there for a long time. Unfortunately, due to an incident, just a fall, she had to go to the hospital. And whenever she came out of the hospital, she had to go through some rehab. All that's covered under Medicare. So there's no extra costs that come from her out of pocket expenses for that. Around day 20, though, they started reaching out and saying that her Medicare benefits were going to expire. And if her Medicare benefits expire, which is like her health insurance, she was going to either have a copay or have to pay out of pocket a substantial amount. Whenever we looked into that, we found out that with just a couple small tweaks, she'd be able to qualify for Medicaid. And because of her personal situation of having a daughter at home, she was able to actually preserve her home value as well. A lot of times you hear about people going on Medicaid and losing their home. And again, it's really, really important that the nuances matter. And so the fact that she had a caregiver daughter that was at home for her, we're able to preserve the equity that she had in her home, get her qualified for Medicaid, which means that she's not coming out of pocket more than her income for that $9,000 a month bill. That's really cool. But then we ran into a little bit of a problem that her power of attorney was scared of. She didn't have money left over to be able to pay for her assisted living bill because they took her income for the nursing home. Her daughter had signed some of the paperwork to go into the assisted living. Luckily, because of the way that we structure things whenever we work together, we could inform her daughter that she was not personally liable for anything with that assisted living bill and that it would have to be what's called an incurred medical expense against Medicaid. And so the family themselves are not going to be out of pocket for that. That's a really, really great thing to be able to tell somebody. Why do I like having those good conversations? Because it takes the burden off of people whenever they're in one of the most stressful times of their lives. If you're caring for a parent or a spouse or even a sibling, it's really, really scary to think about how quickly things change. Often we talk to people who just a couple months ago never had the thought that they would be needing care on their radar. That's what we talk about whenever we talk about troubling times. Something that's going really smooth, and then all of a sudden we find stormy seas. Whenever we find those stormy seas, we want to be a safe harbor for you to walk you through what you need to do to make sure that even if you don't have 5 years, like everybody tells you, to protect your assets, even if you don't have 3 years to be able to protect assets for the VA benefits, there are still options available. It just depends on your individual circumstance. And that's one of the reasons that we offer everybody an opportunity to be able to come in that lives in the state of Georgia. Sometimes we do it virtually, but we find that it's a lot better to do it in person in a safe environment where you feel comfortable and safe and can really go over the details of your situation with a member of our legal team with absolutely no charge for you. Then, if we decide that there is something that we can help with, you're going to be able to get quoted a flat rate fee that encompasses all of what our legal fees would be to help guide you through the process. You walk out of that meeting with a decision made. Either you do decide to work with us and you know exactly what the costs and the next steps are because we give you a roadmap of what that looks like, or it's something where you want to remain unprotected and see how it goes. Unfortunately, the people that don't retain or don't work with us after that meeting usually find themselves on a worse path than what they first see. And that's what we want to talk about here today. Even if it's not something where you want to work with a law firm, even if it's something where you want to try it on your own, there's a couple tools that are very, very important for you to have. Like we mentioned before, a durable financial power of attorney. This helps you avoid having any kind of guardianship or conservatorship process in the future, just based on the fact that you don't have access to a loved one's funds and they can't get to them. The guardianship is a little bit more over the control of a person's body, what we can choose for them if they don't have the capacity to make their own decisions. And an advance directive for healthcare goes a long way in preventing that. A lot of people know an advance directive for healthcare is a medical power of attorney, but years ago in Georgia, the legislature decided to try and call that something different, trying to reduce the confusion between people that had just a power of attorney and thought that it did medical and financial, or only had one and thought it did both. The advance directive for healthcare is something where, as long as you're able to make your own medical decisions, you get to. Nobody's stripping power away from you. What it does say, though, is that if you get to the point that you can't make your own medical decisions, maybe you're in a coma, maybe you have cognitive impairment that's severe, then we're going to allow somebody that knows, likes, and trusts you to be able to make those decisions for you based on your values. This is really important. Whenever a community of doctors is making decisions for you, often they're going to prolong your life or give you treatments that you might otherwise not want. One of the biggest issues that comes up with this is what kind of testing to do. We often know that whenever we're sick, and if the doctors can't decipher exactly what's wrong with us, they want to do a lot of testing. Sometimes, whenever we're the patient in that scenario, we're tired. We know that if they're not going to be able to get us better, we might not want to continue down that road of testing. There are some valid reasons why the doctors want to do that. It's gathering data, it's gathering information, especially whenever you deal with cognitive impairment. We know that right now there's no cure for cognitive impairment. There's a couple drugs out there that can help prolong things, make us stay on a plateau for longer, but there's no cure. The hope is that through different data um, congregations and using different algorithms to figure out, they can backtrack and see if there's more that they can do for that. But unfortunately, right now, if you're the person with cognitive impairment, you have to make that choice of, are you going to continue down that path of testing, knowing that there's no cure for what you have? Or are you going to go ahead and use your quality of life the best that you can right now? Those are decisions that if you can't make yourself, your advanced directive agent can. And that's something that's really personal to you. Some people feel strongly one way, some people feel strongly the other. Another thing that people feel very passionate about is what's called a living will, which is if you ever get so sick that you're in a vegetative state, do you want to be kept alive with artificial means and life support, or would you like to pass naturally? Waiting until you're in that situation to make that decision means that you probably can't communicate it, and so it puts a lot of burden on your loved ones that are there, especially if they have differing views than you. By having a living will in place, which sometimes is part of your advanced directive, it allows for you to make that decision without putting that burden on somebody else. And then lastly, one of the big things that people think is that I don't care what happens to my stuff whenever I pass. And we often find that that's not really a true statement. Whenever we dig a little deeper and start actually talking to you about how things work, if you did pass, you usually care where that goes. Often, if you have a spouse, you want it to go to them. Sometimes you don't. It just depends on what stage of life you're in and what that relationship looks like. Sometimes, if your spouse is on Medicaid or going through some kind of SSI benefits, we don't want them to inherit from you. That doesn't mean that we just give the money to somebody else. Maybe we give the money to them in a protected way using what's called a supplemental needs trust. That allows for them to be able to have the money for their benefit without reducing any kind of government benefits that they'd be eligible for. Sometimes, if you're in a blended family, you don't want it to all go to your spouse because you want your biological children to receive some assets as well. It's very important that if this is something that you're concerned about, that you have it planned out in a legal manner. Unfortunately, it's not like the good old days, even 20 or 30 years ago, where you could do this stuff with a handshake or a self-written will. It needs to be notarized, it needs to be witnessed, it needs to be a formal document. Often, whenever things get contested, one of the most contested things is whether or not the will that's found is valid. Is it the most recent version? Is it executed appropriately? Sometimes people, whenever they do their own documents at home, just don't understand the ramifications of some of the terms. There's a lot of Latin phrases that attorneys like to put in here. Per stirpes, per capita, by representation, all mean drastically different things, and those two words can drastically change who inherits from you. The other big issue is witnesses can't be related to you or your family. Often we see a son-in-law, a daughter-in-law, somebody that's technically related to you that people try and push the limits of and get them to be a witness on a will or a power of attorney. If it's ever contested later, That's going to be one of the first things that they look at to see if it's invalidated. Remember that a will in Georgia needs to have at least two witnesses and a separate notary. A power of attorney needs to have at least two witnesses, and if you want to be able to use it for real property, which is land, it needs to be notarized as well. These are a lot of the execution requirements that are often missed or forgotten, and whenever something happens where we need to use these tools, it's usually a crisis, and we find out that they aren't up to par. By not doing things piecemeal, by making sure you have a real plan with somebody that sat down and walked you through it, that makes sure that you have the confidence of knowing your plan is going to work. Just recently, we talked to a family who has another attorney that's going through the probate process, and she was asking on a Facebook group questions about the probate, even though she'd retained an attorney for her representation. Unfortunately, the attorney she retained couldn't explain things to her in a way that she understood. She felt like he was talking over her and that she wasn't answering the questions. Whenever the attorney asked her to do something that she didn't feel comfortable with and didn't think was her wish, she didn't know how to respond back. And I think that's a scary thing. Remember, even in times of turmoil, it's more important than ever to have a trusted advisor or a counselor that you feel you can speak with, and they can speak back with you without being condescending or coming off in a way that means that you can't continue that conversation. You should always understand what you're doing, and that takes time and it takes effort in a relationship. That's something that we want to make sure that we provide for all of our clients and that you should look for in your professionals. If you get to the point where you've had somebody create a trust or create wills or powers of attorney for you and you don't understand what they mean, give us a call. We'll be glad to take a second look at them and walk you through what you need to do going forward. We know that a lot of people don't understand all the gibberish or gobbledygook, or sometimes they call it legalese, that goes into an estate plan. We want you to understand those things. If you come in and sit down with us and it's something where you have a great plan already, of course there's no charge for that. If it is something where you find some gaps in your plan, we're glad to be able to modify those gaps for you. The best thing that can happen though is that you walk away with a better understanding of where you're at and where you could be by taking a couple steps and tweaks. We look forward to being able to work with you. We're going to continue this session. Keep your questions coming. Over the next couple of weeks, we're going to change path a little bit. For October, we have some really great topics coming through. Just talking about, why do I have a will? If I have a will, do I need to go through probate? Can I just add some of my children to my accounts? Or how should I be able to do a deed to property to avoid probate? I have property in multiple states. What does that mean? The bank said I need letters of testamentary. What now? We want to really focus on giving you guys some quality education, so have your questions ready. We'll go ahead and post the list up of some upcoming topics here in the next couple days, and we really appreciate you joining us. Are there any questions today, Amy? Awesome. Well, for today, we're going to go ahead and wrap it up here then. But again, we want to be a resource for you. We want to help you out. If there's anything that you have question-wise, feel free to reach out to us, and we'll get you some answers.